case on the docket today is Jordan versus SeaWorld of Florida.
Please report. Good afternoon. I'm Joe Williams, and I represent the appellant in this case, Pamela Jordan. Ms. Jordan was a lifelong sufferer from the condition of cerebral palsy. Went to SeaWorld with her fiance. One of the reasons was she was aware that SeaWorld rented wheelchairs to handicapped persons. She was in the park the whole day. When she was exiting that evening, she was in a fatigue condition. Asked the
Counsel, I can assure you that we know what the facts are,
okay,
and I know you're just anxious to answer our questions anyway, which you've been here many times before. I need you to tell me, what the source of the duty is.
The source of the duty is the policy that was developed by SeaWorld to handle the very problem that occurred here. SeaWorld was a good...
Let me just stop you for a second. So let me just kind of do a little elimination here in my mind.
Okay.
Nothing about the rental agreement created a duty here. Is that right?
There was no written rental agreement.
There was not a written one?
No.
She picked the wheelchair up at the point of entry, and they say she was obligated to return it at the point of departure, which kind of makes sense. There's no duty there, right?
There's no duty there, and there are no signs as to where she was required to return it.
Okay. I mean, it's a general proposition. If you rent something from a lessor, you would think you'd have to return it to the point of where you rent it.
That would be the normal procedure.
Yeah. All right. So now we have a policy that you're talking about that SeaWorld adopted. Tell me about that.
Okay, SeaWorld, as a good corporate citizen, envisioned a problem when they rented people wheelchairs and then deprived them of those wheelchairs at the gate and when they're at their most fatigued and weakest point. So their response to that problem, to that foreseeable injury, if you will, their response to that was to develop a policy that said if someone comes to the gate with a wheelchair, and if the attendant, the exit attendant, is required to ask them whether or not they need assistance to their car. If they don't, then the wheelchair is left at the gate, and that's it. The policy says no wheelchairs can go into the parking lot without accompanying by an escort from SeaWorld. So if the person says, I need an escort to my car, then under the policy, the employee is required to call the place where the wheelchair was rented and then get someone to accompany the guest to the car and bring the wheelchair back in. And that policy, as I say, was developed because SeaWorld foresaw that if they didn't do that, people were going to get hurt.
So if SeaWorld's policy had been dump it at the gate, we don't care how you get to your car, we're not going to help you get to the car, we could care less about it, then there's no liability in this case.
That's the Russo case that you just described, Judge.
So you want us to write an opinion which will create law which says you're better off, SeaWorld, to not offer any such assistance, because if you do, you can be liable, but if you don't, you can't be liable.
I don't know if society is better off if the court says that. I'm not sure if SeaWorld is better off, but in what I have striven in this proceeding to do is to contrast the difference between what SeaWorld did in this case and what Disney World did in the Russo case.
Well, let's talk about what SeaWorld did. The only basis of your lawsuit is this internal policy. Is that correct?
That is correct.
This is not a slip and fall because of uneven pavement, pothole, or lighting in the parking lot.
No allegation there was any defect in the premises.
Now, there is a case, Russo, that dealt with a motorized wheelchair. Disney says sort of a Marie Antoinette. If you can't walk, crawl, but we're not going to help you. In this case, the only basis you have is the internal policy, correct?
That's the only basis.
Well, now, in the Mayo case, which was based on the Pollard case, it said courts can't bind institutions because of their internal policy. How do you get around that?
What the line of cases say is that an internal policy cannot be evidence of negligence. There's cases where giving an instruction like that has been reversed. But there is a well-defined line of cases set forth in my brief that says that violation of an internal policy can be evidence of
negligence. But the question is, what is the duty that you have before you get to the negligence? If you don't have a duty, explain to me how you get to the next phase.
Well, if there is evidence in a case of a duty, which there is.
Okay, what is the evidence in this case? That's what I'm asking.
The evidence in this case is that SeaWorld adopted a policy that said if someone in a wheelchair comes to the gate and says they need assistance getting to their car, it is incumbent upon the employee to offer that assistance and to provide that assistance, and through the employee SeaWorld. So the policy sets a standard of care that if the jury believes that, then a jury can find that standard of care being violated was.
Cases you cite give indication of the standard of care in negligence where there is a duty. But in this case, it is argued that SeaWorld did not create a duty by drafting this internal policy. They may be a bad corporate citizen, they may be ugly on that particular day, but they don't have anything that creates a duty to assist people who need wheelchairs.
I don't think that's what the cases say, respectfully, Your Honor. But that's not the only basis for the duty issue or the duty question. I also cited the Union Park Funeral Home versus Hutt case, which sets forth the undertaker doctrine, which says that someone may not have an obligation to do something for somebody.
But once they start to do it. But in this case, there is no testimony, even from your client and her fiance, now husband, that the attendant assisted them and then stopped. All the attendant did was say, you can't take this chair out of the car. Is that fair? That's fair, but the point I'm making is that by adopting a policy requiring employees to take that extra step, that they didn't have to do that. But adopting the policy under Hutt, I would respectfully submit, meant that they assumed the duty to see that the policy was carried out reasonably. And that's what Hutt says. And then there's the other case, which is a state versus Mossad, a state of Mossad, which is the case involving the drunken guest who was abandoned, fell into the pool, and drowned. That case adopts 334 of the restatement, and the restatement says that, I'm quoting here, the failure of an actor to exercise reasonable care to secure the safety of another while within the actor's charge, and then the actor's discontinuing his aid or protection if he's so doing leaves the other in a worse position than he found him. That applies because when she was in the wheelchair that she rented from SeaWorld, she was in their care to the extent that SeaWorld
exercise their control over the wheelchair by evicting her from it at the gate. So in doing that, they left her in a worse position.
I thought you said there were no signs saying that if you needed a wheelchair, we'll provide one and walk you to your car.
I don't think that has any bearing on.
Well, then how would I know if I'm a patient or person who needs a wheelchair that once I get ready to leave, I'll have benefit of it past the point where I picked it up?
Well, the evidence in this case was that specific question was asked and answered in the negative when that was directly contrary to the policy that SeaWorld had adopted. But I think under Section 334, when she's in an appliance that SeaWorld has rented to her, the cases say that they have that duty to carry out their responsibility with due care. And when you rent it to them and then take it away from them when they're at their most fragile state, you're violating the 324 because it says if you leave the other in a worse position than the acting.
Well, but that's the Russo case. I mean, the Russo case, says they can take a wheelchair away from them without liability. So you're arguing that we should distinguish Russo on the basis that there's an internal policy here. And you're arguing that in the face of cases that say that an internal policy does not establish a duty, like this Dunlop case, for example, where the hotel had an internal policy to escort intoxicated guests to their hotel room. How do you distinguish that case, or should we just conflict with Dunlop?
You asked me about three questions.
I know. I always do that. I want to test your talents.
The Dunlop case, I think, is totally distinguishable because the basis for the decision was that the corporation, not the individual, had not implemented the policy of helping inebriated guests get to their room. And there was no allegation in the complaint that the policy had been incorporated. So that's why I think the Dunlop decision doesn't apply. But there is something interesting in the Dunlop case. It says generally where the landowner creates a foreseeable zone of risk, the landowner has a duty to lessen risk or take sufficient precautions to protect invitees. I think that applies to this case.
What risk did the landowner do? Ms. Jordan had been there 4 or 5 times before. The testimony and the judge's order was that she was offered from her own physician a prescription to use a walking support. She refused. She knew the rules at SeaWorld. She'd been there before. So why is it on this particular day, because they have an internal courtesy policy, they're now liable because she fell in the parking lot?
I'm not sure there's any evidence she had been there in a wheelchair before and been in that precise situation before, Your Honor. I think she had been, I think there's evidence in the case that she had been to Disney, and Disney had a policy that you could take manual wheelchairs out into the parking lot to your car and leave them in a corral out there. So, but you asked about Russo. Here's an interesting footnote in Russo that I think helps to distinguish it from this case. The footnote that appears in the case, I'm looking for a page number here, page 774 in volume 721. If Russo had simply announced himself unable to move, there may have been a duty on Disney's part to remove him safely. Now, in this case, Pamela Jordan said, I've got a problem. I need to take this wheelchair to the parking lot. I have a problem ambulating. I think under what's in Russo, you can imply a duty.
Even without a policy? Now you're saying even if SeaWorld didn't have the policy, you can distinguish Russo on that basis, and therefore there'd be liability in this case?
I think that the fact that there is a policy strengthens.
What if there wasn't a policy?
Pardon?
What if there wasn't a policy? Are you saying somehow this case is distinguishable from Russo anyway, or is the only distinguishing factor the policy?
No, I don't say that, Judge. The footnote.
You don't say which it is.
I'm sorry.
I just gave you two alternatives. I'm not sure which you don't say.
Well, what I'm saying is, I think in this case we have a policy and we have a guest saying, I have a problem, which somewhat tracks the footnote in Russo. If there had been no policy based on what the footnote says in Russo, there may still have been a duty to assist the guest. But apparently the guest in Russo never made that complaint or that request. That I can't get there. If you take me there, I'm going to lie down here until somebody moves me.
What's the best case you have for the proposition that an internal policy can create a duty for negligence purposes?
The cases that I've cited in the brief that say that the internal policy with proper instruction to a jury can be considered as evidence of the duty.
Well, we're here on a motion for summary judgment where the court says you don't get to the jury, so how do you get past that threshold?
Well,
and it's the cases you say that you cite, in essence, that create a conflict with Russo and with Mayo, with the other cases involving internal policies.
I think that there are disputed issues of fact that the trial judge did not. I think the trial judge was required under the rules governing summary judgments to say, well, here is some evidence of a duty, and here are cases that say that this evidence can go to the jury with proper instruction. So if that is the case,
I think those cases say evidence of negligence. I think they use the word negligence, not duty, and I think they use it inartfully in those cases. I think they're talking about breach of a duty that comes from some other source.
I would respectfully disagree with
I hope
Judge.
you certainly have that prerogative.
There is a case cited in my brief where the trial court charged the jury that if you find that the standard was violated, that can be evidence of negligence. And that was reversed by the appellate court because it's not negligence, because that's a whole bundle of concepts over and above duty. And basically what the courts say, and there are 3 or 4 decisions cited in my brief that say what you do is you put the standard in, you have an appropriate instruction to the jury that this isn't evidence of negligence, this is just evidence of the duty, and that's the respect you're to consider it in. And then if the jury, considering that, finds that that was the duty, that was the standard, and that was breached, then that instruction will mean that that will be upheld on appeal.
My final question for you is the Kmart case, the Kitchen, in which the court, I think it was the 4th, said that you can't make an internal policy a basis of liability for a corporation. I shepherdized or insta-cited the case, and it's still valid. How do you get around that?
What was the case again, Judge?
Kmart versus Kitchen. It involved the selling of ammunition and death of a child and so on.
I've got 2 minutes left. Can I handle that on rebuttal? Okay, thank you, Judge.
May it please the Court, I'm Mark Thompson, appearing on behalf of the appellee, SeaWorld of Florida. I would respectfully submit that the only issue that this Court need to consider in determining whether to affirm the lower court's entry of summary judgment is whether SeaWorld had a legal duty.
What did we mean in the footnote in Russo that counsel just read to me?
I would submit that, well, first of all, with all due respect to appellant counsel, think he mischaracterizes the facts in Russo, because he suggests that the plaintiff in Russo did not indicate that he had a problem and could not get to his car. This court's decision recites a profanity-laced protest on the part of the plaintiff, in which he made it abundantly clear that he could not get to the car without severe injury. And in fact, we know that he did sustain gangrene and I think had 6 surgeries in the wake of his efforts to get to the car without this ambulatory device. I would submit that the more reasonable interpretation of that footnote is that had the plaintiff indicated an inability to ambulate at all, for example, laying down on the ground, then perhaps Disney would have been obligated to take him out to his car on a stretcher or something like that nature.
Well, what's the source of that duty? Where does that duty come from? Is that a common law duty? Or?
I don't know the answer to that. And I would argue that they may not have a duty, but perhaps their duty is to call the fire department or somebody because a plaintiff is incapacitated on their property. And it may be a gratuitous duty that they assume, but all of this is speculation because it didn't happen. The point that the plaintiff was or that appellate counsel was attempting to make is that that footnote somehow distinguishes Russo from the facts in the instant case. And it does not, because there's no difference in terms of whether or not the person seeking the opportunity to take the ambulatory device to the car protested it beforehand and asserted that they would be unable to manage without that device. There's no distinction between the two cases in that regard. And appellate counsel has endeavored in his presentation and in the briefs to distinguish Russo by, for example, arguing other facts that are not in the record, namely that the plaintiff in the Russo case had been advised prior to coming to the park that Disney had this policy which prohibited people from taking the device out of the park into the parking lot. This court's decision does not contain any such reference. There's no reference in the order of the trial court, which we had a certified copy of attached and sent up as part of the record. So Russo is the controlling decision, I submit, for this court in determining this appeal. The decision involves the same issues under the same circumstances, and it addresses the same arguments that are being advanced by the appellant in this case. With regard to this undertaker doctrine, for example, which emerges out of the restatement section 324, SeaWorld does not dispute that if one undertakes to care for someone, having no duty to do so, but nevertheless undertakes to care for someone who is helpless or incapacitated, they have an obligation to do so with reasonable care.
Well, why is not the directive from the corporate higher-ups to the agents of the corporation that they offer assistance to wheelchair users, why is that not a manifestation of a voluntary undertaking by SeaWorld?
It is a manifestation of a voluntary undertaking by SeaWorld, in that it is an acknowledgement that, you know, this is the policy, but it is not.
Well, it's more than that. It's an instruction to their agents that you have to offer this assistance, and in that regard, it's no different than if one of the agents had helped her out of the wheelchair and started to help her out of the parking lot and then abandoned her at the curb.
I respectfully disagree, and in doing so,
That's your job.
And in doing so would refer the court to the Gunlock decision, in which the rental of a hotel room to a guest did not constitute commencement of performance of that assumption of the duty. Observing the guest to be intoxicated didn't constitute performance in commencement of that duty, and offering him coffee because of his intoxicated condition did not constitute an act in performance of that duty. And the court was able to...
How about if the supervisor, how about if Shamu was standing at the gate and said, ma'am, we'll help you out to your car. Let me just get, one of my employees over here. And he gets on the radio and he calls the employee and says, there's a lady here that needs help to her car, and come over here right away and help her to her car. If they did that much, and then something broke down and the lady got left there for an hour and ended up trying to make it to her car on her own, have they violated the Undertaker doctrine?
Yes.
Why not?
Because they have not begun to act in conformity with that gratuitous...
Why isn't the supervisor telling the lady that we're going to do this for you, and then instructing the subordinate to do it? Why isn't that, the act? We find people guilty of conspiracies all the time for, which requires an overt act for doing a lot less than that.
I think that if we began to push the wheelchair with the plaintiff in it out to her car and it tipped over, or we pushed her into a tree, or somehow conveyed her to her vehicle in a negligent manner, we would be engaged in the performance of that gratuitous assumption of a duty such as to render us liable. But merely in your hypothetical...
So it takes a physical act rather than a communication to set in course a physical act.
I believe it does, and for the same reason that you could argue that reducing a policy to written form is in itself a communication. And so I don't know how you necessarily...
Well, that's where I was going. That's why I wanted to find out what your answer to my question was. Because it seems like there's not any really distinction that can be made between my hypothetical and the facts of this case.
But I don't think, as I said, that your hypothetical would constitute an affirmative, or constitute performance of that gratuitous assumption of the duty. For example, well, I think I answered your question.
Right.
Well, let me give you another hypothetical. You wheel her halfway to her car, and then for whatever, you don't run her into a tree, you don't jump her out of the chair, but for whatever reason, you get halfway there and say, that's as far as I'm taking you. My shift's up, I'm going home, I'm going back. You'll have to walk the rest of the way, and she gets up and starts to walk.
I think under that scenario, you have clearly undertaken to care for her. You've taken charge of her, and you would be subject to liability. And Judge Palmer, you raise another, I think, important distinction between this case and the Mossad case, which the plaintiffs rely on in their brief and plaintiffs' appellants in their presentation today. In the Mossad case, you had a social host who had served alcohol to the plaintiff. The plaintiff had become drunk, stumbled, fallen, gotten a concussion, was severely bleeding, and the defendant took care of the plaintiff and began to care for his injury and his impairment, including giving him prescription medication, which worsened his intoxication. Then abandoned him on the side of a swimming pool where he subsequently fell in and drowned. That's an example of the Undertaker's doctrine. That's an example of taking someone into your care who is helpless and incapacitated and then failing to act reasonably. That is vastly different from the situation in this case, in which we no more took charge of the appellant in this case than we took charge of all the babies to whose parents we rented strollers that day. We don't have any obligation to care for those children any more than we do the appellant. Moreover, the appellant in this case was accompanied and attended to at all times by her fiancé, now husband. She had driven to the park. She had walked from her car into the park She was disregarding the advice of her doctor to use a walker because she felt she didn't need it for vanity and other reasons.
Well, that all bears on whether she was comparatively negligent, right? That doesn't negate, if there's a duty, there's a duty, right?
I think what it does is it demonstrates the lack of incapacity, and it demonstrates how she was not any help.
It doesn't demonstrate that they don't have a duty. So. I mean, if they have a duty, they have a duty, and maybe she's got a duty.
You're right. I agree. What I'm trying to illustrate is how this is different from the Mossad case, and how Mossad is inapplicable to the instant case because
Mossad stands to the proposition that if you voluntarily do some act to assist somebody that you don't ordinarily have a duty, and you're negligent in the way you do that you have liability. You've assumed a duty, right?
That is correct.
Okay, so you're saying that there was no assumption of a duty here, that the manifestation of a corporate policy, a directive, if you will, is not enough to assume the duty. There has to be something beyond that. There has to be some physical act by an agent of the corporation in order to assume the duty, right?
In order to perform the duty.
Well, I guess I'm not sure. I mean, we're talking about partial performance of the duty, right? In other words, in all of these cases, they undertook a duty, they did it part of the way, or they did it negligently, and then they didn't finish, right? I mean, and that's.
Again, I would respectfully disagree. In the Gunlock decision, for example, the court found that despite renting a room, despite observing the intoxication of the plaintiff, despite serving him coffee, they had not commenced performance of the duty to escort him across the street. And so despite their policy and all those other affirmative actions, it is separate.
Even though they had a policy that said they're supposed to do it.
They're separate policies. The policy that related to renting a wheelchair to this plaintiff was different from the policy regarding escorting her to her car.
Mm-hmm.
For the reasons that I have stated, and primarily for the authority that the Russo decision represents, there is no law recognized by Florida that imposes liability on a defendant such as SeaWorld for failing to commence or for breaching a duty that they have assumed gratuitously and not yet begun to perform. That's what the Gunlock decision stands for, and it's what this court's decision stands for in Russo. I submit that this court's decision in Russo is dispositive of this case, and it is all the authority that this court needs in order to affirm the lower court's decision. Thank you.
Thank you, counsel.
Kmart versus Kitchens, Judge Thompson.
Yes, sir.
If you will look on page 4 of my reply brief served in this action, I discussed that case, and I note that the error made in Kitchen was the lower court's instructions that the standard of evidence was evidence of negligence, not of evidence.
I agree with you, but addressing the policy decision as to the court saying we're not going to carve out the special policy when the legislature could have. By analogy, the fact that SeaWorld has an internal policy that you argue creates a duty, Russo argues that it does not, and Kitchen simply says whether or not a policy like that is good for the courts to carve out. That's my only question to you.
And with respect, I'm arguing that it is evidence of a duty, not that it is a duty. That's something that the jury has the right to determine with all of the things they consider. As far as counsel's indication that I had argued that Mr. Russo had called ahead, I think I did make that statement in a hearing in the lower court, and that was wrong. But at page 773 of the decision, the Russo decision, it does say that he went into He boarded a tram, walked to the Ticket Transportation Center, and understood he would be able to get an electric scooter. A Disney employee advised him, however, that electric scooters were only available in the Magic Kingdom. When he got there, he was told in advance of the rental that he could only use the scooter in the Magic Kingdom. I have a fundamental problem with, and I don't have another time.
Thank you, counsel. Well, we're in recess till tomorrow.